The Council of Governors Legal and Constitutional Affairs Committee today held an extraordinary meeting to discuss the issues in the sector and especially to chart a way forward following the Court of Appeal judgment on the Building Bridges Initiative, the BBI. The Council of Governors, in the spirit of honoring the rule of law and constitutionalism, respects and will abide by the judgment of the Court of Appeal. This seems to mark the end of the road for constitutional amendment through popular initiative and Article 255 of the Constitution, but this is not the end of the journey for constitutional reform. The Council of Governors supports the spirit of the BBI and the dream of ending divisive elections that result in electoral violence, ethnic antagonism and competition, and the fight against corruption. We, as the Council, we also hope to see inclusivity among the people of Kenya, increased resources to the counties that will span growth to the rural economy where the largest of our population live. It was envisaged that through these amendments, the county governments would have an increase in the equitable share from 16.9%, which is current, to not less than 35% of the total revenue collected. This increase will enable the county governments to empower the informal sector, small-scale traders, women, youth, persons with disabilities, and other economically disadvantaged groups. As the Council will therefore explore alternative avenues to ensure that the revenues to the counties are increased to at least 35% of the share of revenue as proposed in the BBI. The Council is of the position that the judgment made on Friday by the Court of Appeal did not consider the substantive issues contained in the Constitutional Amendment Bill. The Court's decision largely focused on procedural aspects of the constitutional amendment process through popular initiative. We note that there are clauses that can be amended through a constitutional amendment bill and Article 256 of the Constitution of Kenya, which does not require a referendum. These clauses, as proposed in the BBI through the Constitutional Amendment Bill of 2020, which has already passed through both houses of Parliament. So they were passed, these clauses were passed by the National Assembly, they were also passed by the Senate, and they include one, Article 202 of the Constitution on the equitable sharing of national revenue, which will ensure that counties are adequately resourced. They also include Article 203 of the Constitution on equitable share, and this is the one which provides for increase of the percentage of funds allocated to county governments from a minimum 15% to 35%. This will strengthen devolution and ensure that county governments have adequate funds to carry out their operations. And we have Article 204 of the Constitution, the Equalization Fund, and the amendment seeks to increase the lifespan of this fund from 20 years to 30 years. And this will take care of the marginalized areas of this country. We also look at Article 207, which provides for revenue funds for county governments. This amendment seeks to establish County Assembly Fund as one of the funds in the county, and it will separate the funds of the county assemblies from those of the county executive, thereby strengthening the county assemblies. We also look at Article 215, composition of the Commission on Revenue Allocation, and the amendment provides for an addition 2 members who represent county government, because county governments are not currently represented in the Commission on Revenue Allocation. We also look at Article 206A, which establishes the Constituency Development Fund in the Constitution. We support this because it is further increase of the resources coming to our counties. Then we have Article 207A, which establishes the World Development Fund to comprise of at least 5% of all the county and government revenue in each financial year. And this will ensure equitable distribution and development in the wards of all the money allocated to the county governments. We also consider the amendments to Higher Education Loans Board, which creates a 4-year loan repayment moratorium for university students. We also support the amendments to the Micro and Small Enterprises Act of 2012, which proposes to give the micro and small enterprises a 7-year tax break. With increased resources to the counties to 95%, the county governments will work to empower the small and micro enterprises in the various counties. It will empower the women, it will empower the youth, it will empower people living with disabilities, and also all other economically marginalized groups within our counties. So for us, these are very substantive issues, and we don't want them to die because of the Court of Appeal judgment. Therefore, the Council of Governors will work with other stakeholders, including the Legal Affairs Committees on both the National Assembly and the Senate, to ensure that these amendments are passed through Parliament before the next general election. This is the moment to test the political will, the seriousness and genuineness of those, especially in the political class, who are supporting BBI. We expect them to come out strongly to support the bill which the COG is going to sponsor for amendment of the Constitution through a parliamentary initiative and Article 256 of the Constitution. Thank you very much. That's the statement we wanted to share with you. We have a matrix of those amendments which our Secretariat is going to share with you. Thank you very much.